Phoebe is a relevant newcomer to the profession. She was admitted to practice in October 2007 and came to the bar in May of 2009. Interestingly, before she came to the bar, she had employment as a solicitor at the Human Rights Law Resource Centre and Homeless Persons Legal Clinic, and she also, prior to being admitted to practice, had worked as a legal assistant to Defence Counsel at the UN-backed Special Court for Sierra Leone in West Africa. I mention that because I'm sure in both those areas a number of potential ethical issues arose or may have been seen to be arising. Now, speaking personally, I'm always glad to hear from younger members of the bar on questions of ethics for a couple of reasons. One, because they bring a refreshing view on the way some of the rules operate and the way they see problems. But secondly, because I think the junior members of the bar are often the prey of a certain small number of solicitors who are out there who take advantage of them and try and push the parcel, and both in court and out of court, and really do try and take advantage of the junior members of the bar. And that's particularly so, I think, as we find it's becoming more competitive and the financial constraints are becoming even tighter. So I'd like you to welcome Phoebe and to hear her views.
Thanks, Brind, and thank you all for coming. I feel very intimidated about speaking on this topic because there are lots of traps to fall into, and I hope I don't reveal that I've fallen into a trap in talking about some of the examples I've encountered. And I'm really grateful for Kate for her laying of the groundwork and her advice to you on this topic, and certainly defer to her opinions rather than mine in going forward. I think in being a barrister or a solicitor generally, it's a position of really extraordinary privilege and responsibility. And in my under 2 years at the bar, sometimes it's also felt a little bit lonely, because sometimes you feel that your clients or your solicitors hand you a problem or an ethical dilemma and really say, what should we do, and can you make the decision for us? Or we've got this, what first looked like a present with a pink ribbon around it. When you unwrap it and start sifting through it, there are little bombs or things that look like they might turn into a bomb. So I found that since coming to the bar, this has been one of the challenges, and it's why I wanted to come here today to just give you some of the examples that I've encountered and what I've done in response to those problems. And my 3 strands of advice on those from that limited experience is, firstly, take time to respond to the issue or the problem and to reflect and to get advice. And I say that because litigation is time pressured and stressful, and often there is pressure to make a decision, to move forward, to announce your appearance and outline your case. And things do happen immediately before court, and counsel on the other side, they do say things to you that indicate that maybe there's an ethical issue or a problem that you might not have been aware of and you need to deal with. So I've learnt to take a breath, if I need to stand the matter down or adjourn the matter, and to, secondly, my second strand is to get advice. And that is both to my colleagues, and I have kind of a panel of them. People on my mobile phone who I can call outside court or in any situation, and they range from people at my level, and I think that they provide relevant, important, invaluable advice. And also there's a few silks on my floor that are used to a knock and a, hi, can I just run this past you? You know, I'm not sure whether it's crystallised yet into an ethical issue, but I just feel nervous about this. There's something about it that strikes me as a little bit peculiar or offbeat. And that's the sniff test that Brind and Kate referred to, that if you need to ask, it's probably a good reason. And if you've got that nervousness in your stomach, that's something that you should listen to. The third piece of advice, and this was something that was given to me by a wise silk on my floor, was to strive for clarity in the role that you perform. And this has been enormously useful in dealing with ethical issues, that I'm briefed as a barrister to perform a particular role and that I should try to avoid going outside that. Now, that might be a bit counterintuitive or a bit unusual, so I'll deal with that in a bit more detail. As I've said in my paper and I've said here, this advice is really just based on my experience of under 2 years call, but also reflecting on my experience performing different kinds of roles as a corporate solicitor, a policy lawyer, a human rights lawyer, a lawyer acting or a legal assistant acting for a man accused of the most heinous crimes that you can level against someone. And the examples I've had, and this is not uncommon for junior barristers, is receiving, and this has happened 3 times, so solicitors be aware of this, direct correspondence from a client about their frustration with the solicitor. That makes me feel very uncomfortable. I don't like receiving it. I don't like the position it puts me in. And I've found Rule 29 in that regard very useful, that is the extent of my role. My role is to engage in that debate or that issue only if I think that the solicitor's conduct amounts to a way in which it might be in conflict with the client's interests. And to not get involved in mending that relationship and to try to simply say, it's your decision who you instruct. I want you to feel comfortable with that, and I want you to feel that your solicitor is acting, and obviously it's your choice at any time to find someone new, and I'd be happy to be involved on an ongoing basis if that happens. But to not really get too involved in that. The second example, and this has also happened twice, is where a client's going to give evidence in a civil proceeding that might prejudice his or her rights to a fair trial. The first time this happened was when I announced my appearance, and as I indicated to my client sitting in the first row, Your Honour, I appear on behalf of, I noticed a prosecutor in the back room of the court handing my client a business card and saying, Mr. Smith, we'd like a few words. Could you come down to the police station after court today? And it kind of was just, excuse me, Your Honour, sorry, would we be able to, I had just announced my appearance. Could we just stand the matter down for 15 minutes, please? Because I wanted to know what was happening. The facts of the matter were my client was a defendant. The company was suing him for taking funds out of the safe. I had been advised by him that there was no possibility of a criminal investigation and that he had already spoken to the police and that had been dealt with and was resolved. Well, it was clear it wasn't resolved, and it was clear that there was still interest. And much to the plaintiff's counsel, we successfully applied for a stay on the basis of an on-foot criminal investigation into precisely the same conduct on which he was going to be giving evidence in the civil proceeding. And that happened again more recently. The other example is being briefed in a matter where a client had gone on affidavit alleging fraud, and there are specific rules for solicitors and barristers in that context. In responding to these rules, these issues, I've gone to the bar rules, other counsel and solicitors and the Bar Ethics Committee, and I have obtained a ruling from the Bar Ethics Committee on one occasion. And it was an enormous relief at how quickly that occurred and the clarity about what I should do and how I should implement that. So your professional conduct rules are enormously useful, and I think Kate's right that sometimes we don't realise the detail that is there about how to step through a process, and it gives you great comfort to know that you can, about A, B, C, D. I guess in terms of my A, B, C, D and just a brief step-by-step process, the 4 things that I try to do is this. Firstly, to generally be aware of ethical issues. Now that sounds kind of trite. That sounds like groundbreaking advice, Phoebe. Be aware of ethical issues. But I actually mean it quite seriously, and I'll talk about it in a moment. Secondly, if an ethical issue arises, be cognizant of the different principles that you apply and how you're going to apply them. What do the bar rules say? What do the different sources, what do other barristers say? And as Kate has said, there will be different views about how to apply the rules and what the rules are. Finally, determine how to apply the rules and then communicate your decision. And sometimes this gets a little bit muffled or put to one side. But to be clear that I have considered this issue, this is what I think the issue is, this is how I've, as Kate said, I've looked at this rule, this is what the rule says, this is what my decision is, and so this is what I think we should do going forward. Because that gives you and everyone a framework about the scope of your decision. It's not a decision about how to repair the solicitor-client relationship going forward when they're at loggerheads. It may be, but it's, if you articulate it, I think that gives everyone some comfort. So, what are the ethical issues? If you think about the most straightforward litigation of client, solicitor and counsel times 2, that's 6 people. You immediately have, in the most simple litigation in hearing, 6 people who come to it with different perspectives and different agendas and different personalities. We all know that we have a different way of advocating and a different way of performing our role as a solicitor as the person in the office next to us. Now, often that doesn't mean that an ethical issue arises, but it might. If you have, and then you build that out. You have 2 people in your client, 2 people in your instructing solicitors, maybe senior junior counsel, and then times 2, times 3, times 4. Just having a moment to think about that, I think, is useful. I've certainly been involved in cases where the client has 2 different people instructing quite differently about the way in which the conduct of the litigation should be run. And similarly, a solicitor with quite a different level of appetite for litigation than the client might have. And you need to be aware of that, because in those circumstances, it might produce an ethical dilemma. And the other reason I do that is to also, as I say, and this is chickening out, but I do it and I think I'm on fair ground in doing it. Sometimes there are issues that I see that I put to one side and I say, that's not my role and I'm not going to, I'm aware of it, but I'm not going to respond to it. And as I say, that might be where the client's worried about going forward, how they're going to get along with the opposing party, and that might be issue relevant to mediation. But, you know, they've got to make that decision and then instruct me how to conduct the litigation so that I can. What principles apply in terms of step 2? I just wanted to have a bit of a frolic here, and in addition to the hard rules or the bar rules and the Civil Procedure Act and the case law, I have actually found some of my university studies here very useful. And at the time when I did ethics, I found it a little disappointing because I was interested in the subject and I found it a series of buzzwords that was trying to label or put into a neat structure something that's quite nuanced and philosophical. But I actually have found it very useful since coming to the bar, and it's for, I guess, lawyers, 4 different kinds or categories of lawyer. And I think sometimes we're each a little bit of all of this. Maybe not like wind in the willows, but we do have an element of affinity with one or more of these roles, and they're loosely termed adversarial advocate, the gung-ho adversarial advocate, a responsible lawyer, an ethics of care lawyer, and a moral activist. And I'm aware that a lot of you are solicitors, and I think as solicitors there's a little bit, sometimes a bit more leeway than as counsel. The cab rank rule as counsel certainly means that ethics of care and moral activists are a little bit, a bit difficult for you, and I'll explain what I mean by that. So for the purpose of this frolic, let's assume that they're each capable of compliance with the rules, the Civil Procedure Act and the Legal Profession Act. Sometimes, maybe a big assumption, sometimes they might fly a little bit close to the wind. The adversarial advocate, as I said, is your gung-ho lawyer who will use every strategy and rule in the book to pursue their clients' interests. I think the Civil Procedure Act has curtailed this a little bit in terms of certification that you think that there's merits and that what you're doing is necessary. But this might be to use the rules to flush out, to bleed dry, to swamp in discovery. Now that's at the periphery and that would be unethical. But coming back from that, it might be to act within the rules and to firmly argue your case because you're in a system where the court will come to the best decision. And an adversarial system depends on both sides arguing. The responsible lawyer is a little bit of adversarial advocate, but acts within the spirit of the law. And I think out of the four approaches, this probably exemplifies an ethical approach to lawyering and tries to or places emphasis on their paramount duty to the court. And they see themselves as a guardian of the system and so won't flaunt the rules or exploit the rules for their client's gain if they think that that's not just improper but coming back from a little bit. The moral activist approach and the ethics of care, the last two, as I said, I used to work as a human rights lawyer at the Human Rights Law Resource Centre and the Homeless Persons Legal Clinic and a policy lawyer. So in some of those cases we were running test litigation where we were, as an organisation, we could choose to take on the clients that we wanted and to run litigation that was in our organisation's policy aims and mandate. So it says that you can never let the system sully your ethics. You can never let it make you become a party to an unjust outcome. Now, unfortunately, in our courts, there are unjust outcomes every day. And as a barrister, where a case is argued on a narrow footing and there's an outcome, I feel there are sometimes outcomes that might be viewed as unjust. A moral activist would be very reluctant in that situation. The final one is ethics of care that tries to preserve relationships. And this is part of us generally to try to mend relationships. And it might have application in negotiation and mediation in trying to preserve relationships. But it's something that I see as this is one area where often I'm not briefed to do that, or it's a component of it, and I'll recognise, advise on it, but the bulk of my other work is a bit, I'm briefed to do certain things. And so in applying the rules and the principles, I've been advised to determine what my role is and then don't go beyond that. And I mentioned this at the beginning and I just want to explain it here with an example. In my first present Supreme Court trial, unled, wow, how exciting, but of course, fool was I because I received it, the Friday before the Monday that it was due to start and worked on it all weekend. And my solicitor, the partner, said, now it's about whether or not a guarantee in a contract is effective and we're defending it, where the party the guarantee has been called on. We say the clause doesn't amount to a guarantee. It was drafted by the other side and I advised on it, and I advised that it might not be effective, but because that might become an issue, my junior solicitor is going to have the conduct of the matter, and I don't think it'll be a major issue, so let's... Now, I really should have had some louder alarm bells going at that point, but I didn't, and I was eager, and I thought, wow, great, this is great, let's go. So I worked all weekend, including preparation of cross-examination of the other side, and arrived at court, and as unfortunately, the opposing counsel hadn't been able to give me notice because I had only been briefed on the Friday. So at court, she said, I want to call your partner of the solicitor and I want to cross-examine him. And I was kind of, wow, all right. And she also said, look, I think that he shouldn't be instructing. And I said, well, he's not. This other solicitor is, but same firm. And she said, well, I think that if this continues, I'm going to have to report him to the Legal Services Board. Ooh, okay. All right. So Rule 29 became very useful in that circumstance because it really set down a framework. And I stood the matter down and spoke to the client, spoke to the solicitor, came back to Chambers first. I said, I just need to take a moment here. Went back to Chambers, spoke to my mentor. I was still in my reading period, and spoke to a silk on the floor, and that was the time that I got a ruling from the Ethics Committee. They were very, very quick, and I didn't realise how quick it was that I had a ruling before we were due to go back to court 2 p.m. that afternoon. And I implemented that rule. To my surprise, and it was a good lesson, the clarity that the rule provided me about what I should do and how I should do it. So I spoke to the solicitor, advised them that I felt that they were conflicted, put that in writing, told them that I thought that they should withdraw, and that if they didn't, that I would need to tell the solicitor that. They agreed that they should in the circumstances. And so that all went relatively, to the extent that it could, without a hitch. The next question that emerged, though, was I'd prepared cross-examination and I advised the client to seek an adjournment and that to seek new solicitors. I couldn't act without instructors in the Supreme Court. And my client didn't want to. They wanted to push on, which was fine, but they wanted me to help with cross-examination. Now, at that point, my role was different. And this is what I mean by clarity of role. I was briefed as counsel. I couldn't appear as counsel in the Supreme Court without an instructing solicitor. So I was no longer counsel. So if I was continuing to provide advice to my clients on cross-examination, what role was I filling and what was I doing? Now, intuitively, I felt, yes, I've got my cross-examination, but it's also something that I've prepared that I know how to deliver, that apart from whether or not that's even fair to someone to say, take on my cross-examination, it was also bleeding and blending roles in a really dangerous way. So my inclination was, yes, I'll help you. Came back to the floor, spoke to my wise silk, who said, that way danger lies. Do not. Your role is counsel. If you're performing some pseudo role as friend of the court when you're a lawyer and counsel or previously briefed in the court, and the client wanted me to sit in court, unrobed, but at the front, it was just bizarre. Yeah, Kate's saying that juniors getting preyed upon. Is that what you said? Yeah, indeed. So have the courage to kind of step back and say, I can't, I've advised you to adjourn, you haven't, the result is you have no counsel. So I did. And I said, I'm terribly sorry and I wish you best of luck with it. Invariably, they lost quite a lot of money, but I was briefed as counsel and I can't fill this other helping hand role. I would love to as a human being, but it's dangerous. So that's my advice. And I guess finally, the final step, as I said, is communicating your advice and obviously take good notes of what you do and why you do it if it ever emerges that you need to recall all of that. Thank you very much.
Thank you, Phoebe, for sharing those experiences with us, particularly the last one. As I say, it was the younger members of the bar certainly do get preyed on from time to time. Now, there is some time for some questions. If anybody's got any questions they'd like to put to either Kate or Phoebe, or even I might try and help answer too. Is there anybody got any questions they'd like to ask? Yes.
Okay, I know it's probably not the forum for asking specific questions, but if I just set out sort of the general outline of something that has happened, could you indicate what may or may not be an appropriate course of action? I won't say any names, but imagine you were briefed to take a legal aid matter, and as sometimes happens, you received the brief the morning of, simply you were told by the instructing solicitor that your client would turn up with a medical certificate confirming that he had cancer, and that on that basis, the burglary charge should argue that he shouldn't be in prison. Client turns up in the morning, gives you a letter, everything's perfect, says absolutely what you think it's going to say. You stand up in the course of your plea, tender it. The magistrate looks at it and says, well, I've got some concerns about the authenticity of this. Have you made inquiries? And you say, well, I haven't made any inquiries as to its authenticity. And then the magistrate hands it.
What authenticity, what meaning? It was a truthful...
Meaning the magistrate thought it might be fraudulent.
Yeah.
And you'd already run past the prosecutor, everyone was happy. So the magistrate then says to the prosecutor, I want you to make some inquiries, hands it down to the prosecutor, who then rings the doctor who allegedly wrote it, who's not there. Your client then says, well, just untender it, just carry on without it. And alarm bells start ringing, and you say, well, I can't really do that. So you stand it down. And the doctor comes back the next day and you say, well, the matter has to be adjourned, inquiries have to be made, leave court, get a phone call about 9 o'clock that night from an intoxicated client who's apologetic and confesses that he may have in fact photocopied something that he typed up onto it. And then you turn up the next day and there's a detective senior constable who's going to charge your client for attempting to pervert the course of justice and wants a statement from you. So it's not a simple question of standing up and saying I can no longer act, which is obvious. The next bit is, what do you do? How do you participate in the ongoing investigation? Do you simply say my involvement's a matter of public record, everything else is privileged? Or what happens there?
That was my first thought.
That's,
privilege.
yeah.
Brind's more expensive.
Well, that's what I'd be saying. It's privilege, and it's for the client to waive the privilege. There may well be an argument, so far as the prosecution is concerned, that because the instructions you will assume were false, that it was genuine, that therefore any communication given to you in that regard was not subject to privilege. May also be arguable that it's not subject to privilege full stop, but that's what I'd be doing so far as I was concerned, and I wouldn't be divulging anything without the client's consent or an order of the court. Okay, all right. But very difficult, and perhaps it's just one has to be very careful, if I may say so, with medical certificates and the like, because that often does happen. For example, I will not tender a reference unless it's made very clear that it's for the court and it's in relation to particular charges. Anybody else got any questions that they'd like to ask? No. Okay.
I've got a war story that I've...
She's got a war story.
Reminded me, Phoebe's talk reminded me of it. A junior member of our bar on our floor, my floor I should say, had been briefed to make an to appear on an application for an executor's commission, and the affidavit material conflicted with the instructions. The affidavits started off at a particular time, and then I think maybe the first solicitor didn't realise, the second solicitor I should say, in giving instructions didn't realise that there was an earlier memo And so there was a lie in writing in the memo. So the barrister came in and said, what should I do? And I said, you should do a memo and say that you need to file a further affidavit explaining the discrepancy and putting what was the true facts in. And I think the barrister, I should say, it was the first time the barrister had been briefed by this firm, and it was very difficult because the solicitors said, no, you are to go to court with the original material. And I settled a memo for the barrister saying, no, we won't do that. It's unethical, and if you would wish, we would get a ruling from the Ethics Committee that we will return the brief. And what they then responded back was, you don't need to do that, you're sacked. And by the way, we're not going to pay you your fee. And the barrister, well, not just because the barrister was young, but also it's just a very upsetting experience. And so there was a bit of correspondence about the fee, but not very much, because the solicitor then reported the barrister to the Legal Services Commissioner, which then commenced an ongoing investigation. And the barrister had all of the stress and trauma of having that ethical complaint made against her. It was, I shouldn't say it does, him or her, doesn't matter, but it was just a reminder of my view was, you've got to stick to your guns. It's a real bullying exercise for the solicitors to do that. And eventually, because the Legal Services Commission goes very slowly, eventually the claim was dismissed and the full amount was paid, but it was about a year later, plus all the stress and strain of it. And my view to the young ones is, you know who the bad solicitors are, and unless they've got money in trust, I wouldn't touch it. And I mean, but you've got to have a bit of background to be able to find out who the dodgy ones are. But I think the young ones, but I was aghast at the behaviour of the solicitor. I couldn't believe that they would instruct the barrister to go to court and say, you've got to stick with the first story, even though everybody knew it was wrong. So, I felt very old. I don't know in terms of the other that the commissioner's in. No, it ended up, you know, you have to put money in if you're going to argue about the fees, and I think they might have put some in or something. But there was another technical reason for it to be dismissed, and it was. But the barrister had to work really hard to get the commissioner to take the decision to dismiss it. But it just left a really horrible taste in everyone's mouth.
Thanks.
There you go.
Thank you. Just before we close, can I just recommend you all go and have a look at a favourite case of mine. It deals really with Rule 29 quite directly. It's a case called Hattie and Pilkington, Pilkinton. It's reported in 108 Australian law reports at page 149. Mr Pilkington was a solicitor who appeared on what we'd call a .05 charge for a lady, and at the time he appeared for her, he knew that she had given the police a false name, and he entered a plea of guilty under that false name. And he was subsequently charged with attempting to pervert the course of justice based on the fact that he knew that she'd appeared in court under a false name. In the Magistrates' Court, he was convicted. On appeal to a single judge in the Supreme Court of the ACT, he was acquitted, and then went to the full court of the federal courts, full court of the federal court. And the full court unanimously said that he was guilty not only of attempting to pervert the course of justice, but of an actual perversion of the course of justice, although he hadn't been charged with that. But they made it very clear by way of obiter that it was actually an actual perverting. And in the course of handing down the decision of the court, Chief Justice Michael Black deals directly with the argument that Mr Pilkington was under an obligation not to disclose anything to the court which was adverse to his client. And he demolishes it very, very simply and very quickly by saying Mr Pilkington had a very simple course of action to do, namely he could say to the client, I've got to tell the court what your real name is, And if you don't give me permission to do that, I can no longer appear for you. So it's a simple example, and it shows you how the rule works. May I say on behalf of us all, thank you very much to Kate and Phoebe. It's been very revealing, and congratulations to both of you for some wonderful insights. And thank you all very much for coming along today, and congratulations all on earning another point.